decided to use my laptop instead. Okay. Okay, now, civil justice reforms. In 2009, well, between 2000 and 2009, now remember before our break, we said that civil litigation system in Hong Kong is expensive, risky, takes too long, too much publicity, too complex for laymen, remember? That's what we said before the break, right? So, because of those criticisms in the society, there's a working party established on civil justice reform in the year 2000 by the Chief Justice, or by the then Chief Justice. The purpose is to review the rules and procedures of the High Court and to make recommendations on how it can be better. So, not surprisingly, many of the criticisms or the downside that you have recognized are on the list, right? The ones recognized include too expensive in terms of legal cost, the outcome is too uncertain, cost is unproportionally or disproportionately high, too slow in bringing the case to a conclusion. Also, the procedures, the complexity is all disproportionate to what we need. Also, remember I said, yes, sometimes a party, one side, may engage in delay tactics, right, to slow down the progress of the case, right, making rounds and rounds of applications that are not necessary. Or else, perhaps, what if one party, one side, engage in very expensive counsel or legal team, and the other side, it would be very risky on the other side, right? If they lose, the legal cost will be exceptionally high. So sometimes it's scary for the other party, right? And they may decide to retreat for the simple reason that they think they can't pay in the end, right, if they lose. Okay, too adversarial, running of cases in the hands of the parties rather than the courts. In other words, the court is too passive, right? That doesn't take enough lead to push the progress of the case. Too difficult, too incomprehensible, too hard to understand to most laymen. Right? If the people are litigants in person, they don't know where to start. Does not do enough to promote equality between litigants who are wealthy and those who are not. Yes, and the last point, too passive a role in admin and case management. As a result, several amendments and also new legislation made, okay, or passed. Civil Justice Miscellaneous Amendments, Ordinance 2008, and also rules of High Court and rules of District Courts amended. A whole chunk of 24 practice directions came into effect. Right? So all aim to eliminate or reduce the problem that we have talked about. So theoretically, what are the underlying objectives under the CJR, Civil Justice Reform? Supposedly, it is to increase the cost effectiveness of practices and procedures in civil proceedings. It is to ensure or to encourage that a civil case be dealt with as expeditiously, meaning as quickly as possible and practicable. To promote sense of reasonable proportion in terms of cost and time and procedural complexity. To ensure fairness, right? Because you can't just say, yes, we want it fast, we want it cheap, without doing justice. Right? That would defy the purpose of the court system. To facilitate and encourage settlement of dispute via alternate dispute resolution. Okay, if you can mediate, that good. If you can settle by negotiation, arbitration, whatever, okay, better. Okay, to ensure fair distribution of court resources. Litigating parties and their lawyers are now expected to adopt an approach that is cost-effective, efficient, reasonable, proportional. Consumption of court time should be reasonable. So all this, they keep on repeating, yes, those are our objectives for the CJR. This is what should be achieved. Now, many would differ that after the CJR, have those objectives been achieved? Okay, so some say yes to a certain extent, some say no, it's worse, some say yeah, bit by bit, hybrid, etc. Okay, under Order 1, capital A, Rule 2 of the Rules of High Court, court must seek to give effect to the underlying objectives when it exercises any of its powers, or interpret any of these rules or a court practice direction. The court should recognize the primary, the main aim in exercising their powers. The primary aim is to have just, meaning fair, the just resolution of the dispute in accordance with the rights of the parties. Substantive rights meaning, your liability, your substantive legal principles, like your contract law, your tort law, etc., etc. Those rights and obligations. Now, since the CJR, the court is told that it shouldn't, or they should not be passive in case management, and they should take a more active role. Okay, so what does that mean? Okay, encourage parties to cooperate with each other in court proceedings. For example, instead of making an application, right, let's say you want a time extension to file a witness statement. So instead of just making the summons, making the affirmation, and applying to the court, you are expected in practice to ask the other side first whether they can consent and agree. Because if you hand in or file an application with the court then have to, process your application on paper, give you a time for hearing. The court then have to reserve a time for the hearing, right? And decision has to be made. So court resources and court time. So let's say you only want like a 14-day extension of time to file the witness statement because your witness is in Canada, right? Just a bit more time. So let's say you're the plaintiff. What you would do is, yes, you would try to write to the other side. You would see if they agree. It's only 14 days, right? And if the defendant side agree, you would put in what we call a consent summons, which means that you're putting like a joint application before the court. It's not exactly, it's a hybrid, because the court, if it's quite ordinary application, would just approve it without a hearing. And that's the purpose of consent summons. Okay? So that's what we mean by, yes, the parties should cooperate where they can. And let's say if the defendant is naughty and want to give you inconvenience and say, no, I won't agree. Well, they have to act reasonably. Or else when the parties, so defendant doesn't agree, I have to put in that application, right? Otherwise, I don't have my extension of time. Right? That's my only way because the other party is not agreeing. So when I hand in that, file that application to the court, the parties come before the court. If the defendant had been unreasonable, he's going to be told, why didn't you agree? The court will actually give them or criticize them, right? Because it's a simple application. It's not oppressive, it's not prejudicial, the other side is also expected to act reasonably. Right? And that's what we mean by encouraging parties to cooperate. Identify issues at an early stage, and that's why we have what we said, the pleadings, right? The storytelling, and the witness statements exchanged, and also the process of discovery. So everybody knows, each party knows what is on the table. Okay, what cards are on the table? Okay, who has what? Because at the end, when we progress and get close to the trial, perhaps in the beginning, your pleadings document, when you're telling the story, you may have 10 things or maybe even 15 things you disagree on. Okay? Yes, the contract was signed on the 25th, not the 27th of December. Are those important? Okay? The closer we get to the trial, because of the discovery, well, we actually get to see the actual contract, right? So it would be quite obvious which is the correct date. More things disclosed, the parties would narrow their differences. Okay, they would narrow their differences and the amount or the number of issues that they are going to argue at trial. Some issues, maybe they would be considered as in, yes, I agree with the other party. Now I can see the document, I agree I was incorrect. Their version is correct for some issues. Some other issues, maybe there are a few more issues that are maybe both party thinks it's not really central to the dispute. Let's drop it. So we want to distill the issues to only the main necessary issues at trial. Okay, and that's why we identify issues at an early stage. Deciding promptly which issues need full investigation at trial and disposing summarily of the others, exactly what we're talking about. Right? Some issues not important, drop it. Okay? Others, maybe you can agree, etc. Deciding the order in which issues are to be resolved. Now, what if some issues, they go, although when you tell a story, you go in chronological order, but perhaps issue A would have a direct impact on issue B, so the chronological order of trying on those issues are important. Encouraging and facilitating the use of ADR procedures. Okay, perhaps, well, the mediation certificate is an example. In the family court nowadays, there are now two schemes that the court will try to get the party to negotiate. Okay, it's almost like a court-assisted mechanism. It's called, okay, we don't need that. Okay, so we have something called a CDR, Children Dispute Resolution, that deals with children matters, and a Financial Dispute Resolution, FDR, that deals with division of assets disputes between husband and wife. Now what those are is like court sessions, but the court will help you to define, help the husband and wife, for example, to define the issues, to define who says belong to what, when, how, is there any way you can settle? Okay, what are the bottom line of each party? So it used to be a pilot scheme a few years ago. Now it is formally inherent in all of those proceedings. Okay? You do not have to learn about those until you actually do your family law, but these are just some examples of ADR procedures. Okay, rather than fighting till the end of the case. Helping the parties to settle whole or part of the case. Fixing timetable or otherwise controlling progress of the case. You saw that in the flowchart there's something called the timetabling questionnaire. That is like exactly what it's called. It's a questionnaire that has to be filed by each party. The first time they have to file, each party has to file it is after the discovery stage. So they have to tell the court what they think they've done so far in terms of sorting out the progress of the case? Do they need, what kind of interlocutory procedures do they think they will make? Will they be asking for summary judgment? Will they be asking for interim payment? And so on and so on. How complex do they think the case is? How many witnesses do they think they will have? Do they need expert evidence? All those. It's actually a very, very long document. Okay? So the court has an idea of how much attention, how much procedures would be involved. Considering whether the likely benefits of taking a particular step justify the cost involved. Those happen when particular applications are made. Dealing with as many aspects of the case as practicable on the same occasion. So let's say you have an application for interim, you are the plaintiff. You are seeking an application for interim payment. Basically that means to get the defendant to pay part of your claim if you have a very high chance of success. Okay, that's one of the application we learned. But for present purposes, it's just the plaintiff asking for part of the money, okay, before the main trial. And let's say the plaintiff is also asking for an extension of time to adduce expert evidence. So if there are, let's say, 2 or 3 applications, if they can be made in one go, you should make them in one go. You shouldn't appear before the court 3 times for 3 separate applications if you can combine them. That's what it's saying here. Dealing with the case without the parties needing to attend court. Now, if you happen to hear or be in the industry during the COVID-19, right? You guys have been doing Zoom and online learning, online classes, teleconferences, rather than physical meeting, right? You have reduced physical contact. Well, just think of it that way. Even without the COVID, when the court can make directions on paper, they will try to. What we call paper disposal. So let's say, yes, I made an application, a simple application, let's say extension of time. Okay, the other party is not giving me consent, so I still have to make my application. Well, the court may decide to just grant it, okay, on paper, if the application is very simple, and to save court time and resources to skip a hearing, to not conduct a hearing. Okay, if it's very simple, no need. Okay, the court may just give directions on paper, and that's called paper disposal. Making use of technology, such as, well, I think we have video hearings now, right? In, I think at the court of first instance sometimes. Giving directions to ensure the trial proceeds quickly and efficiently. Those have to do with case management directions, such as making sure that people are ready. They can include anything from timetabling questionnaire, which we talked about, to criticizing and directing trial bundles to be prepared better, throw out all the irrelevant documents, okay, things like that. Shine Grace Investment Limited and Citibank N.A. These are just some examples of what the court may do, okay, in view of its more active role. Late application to amend pleadings less than a month before the trial was rejected. Such application was held to be unjust and likely to derail the trial date, causing prejudice to the other side. Now, it's always a fine balance. Okay, of course, we're going to say, yes, too late to amend pleadings. Why? Well, when you get to know about pleadings, it's like we have an adversarial court system, right? So it's like a tennis match or badminton match. So this side change something, hit the ball over the other side have to respond. So let's say in if the plaintiff amend his pleadings, which we call a statement of claim, if the plaintiff amends a statement of claim very close to trial, well, the other side might not have had time to respond because the pleadings define the whole case. If the story changes, the whole case and how you should conduct the case may change. Okay, let's say originally the plaintiff is only suing for breach of contract. Now he wants to add another cause of action. That has very serious implications, right? Your evidence, what's relevant, what's not, the defense side, the pleading court, the defense will also have to be amended to respond, etc. Right? It's very costly. It would probably throw out the trial date because there's just not enough time, okay, to respond to that change. So the court can refuse the application. Right? Many of all these applications and amendments are all subject to the court's leave, meaning permission. Leave as in L-E-A-V-E. You see that a lot in your course manual, right? It just simply means permission, right? Leave. As in asking someone to leave, just means permission. You see that a lot when, for some reason, they like to use the word leave, okay? Just means permission. So all those are not automatic. You're not automatically entitled to change your pleadings anytime you want. You cannot file documents anytime you want. All those are subject to prescribed time limits and subject to, otherwise, if you're out of your time limit or the stage of pleadings has closed, what we call, you have to get leave from the court. Okay, you can't just do what you want. On the other hand, let me give you an example. Okay, say, okay, you amend your pleadings too late, you cannot, we will not allow it. On the other hand, I think was it last year? Just last year, I was involved in a trial, and the court said that my side should have amended our pleadings, our statement of claim, even up until judgment. Now that's very, very weird, and that's very rare. The reason for that was that during the trial, the oral evidence of the other side revealed something, okay, revealed a weakness that we can actually attack. Okay, and that actually had bearing on the case, the whole case itself. So we actually didn't amend the pleading, and we were criticized by the court. And we said, Your Honor, it's so late, we're already at trial. And what his honorable judge said was, you can do that right up until before judgment. So that's another extreme. So depending on your rationale, it is always a balancing exercise. Okay, so yes, we tell you the general rule, but there are always exceptions. The other case, Lu Guoxiang and Hong Kong Minhua Shipping Company Limited. Directions given regarding case management should not be easily departed from, as the legal profession must be able to plan ahead if they are to operate efficiently. So basically, these two cases, the general principle is that you should keep on track of the planned time and schedule, basically, right? To not throw other people off track, okay, in terms of time, in terms of efficiency. Powers of active case management, what can the court do? Now, bearing in mind that this powers doesn't have to be on application by a party, and that's what we mean by active case management. Okay, so the court can do it on its own initiative without a party's application. They can extend, or the court can extend or shorten the time for compliance with any rule, court order, or practice direction. They can adjourn or bring forward a hearing. They can require a party of its legal representative to attend the court. Now, there are particular rules and provisions on this type. and also here. Now, there are instances when the party at an interlocutory application simply do not appear. Okay, so what implications does that bring? Okay, so the other party is at a loss. Okay, should we adjourn the hearing? Should we wait? Should we make the decision now? Okay. Well, first of all, the general principle is that yes, the court can actually make a decision without the other party if it is certain that that party had been notified and served, but decided not to appear. That's first of all. Secondly, most commonly what the court will do is, perhaps it's the first time that, let's say it's the defendant. Perhaps it's the first time that the defendant didn't appear at this application. The court may decide to give the defendant one chance. So what it may do is, okay, the summons or application by the summons is now adjourned to a date to be fixed, or to 3 weeks later, let's say 3 weeks later. On, where are we now? Let's say 26, right, 3 weeks. To 3 weeks later, on the 26th in court 3 at 10 a.m. Okay, so adjourn to a later date and time. The defendant or his legal representative, on the order, it would actually, on the directions order, it would actually also say both parties or their legal representative are to attend at the hearing. So to specify, even though they should anyway, right? If you have a court hearing, you're supposed to attend. But if the court want to push it a little bit firmer, that's what kind of directions they can give. Okay, and other typical circumstances when this happens is perhaps, sorry to say, but family proceedings. Sometimes one of the party doesn't like to appear. And in those proceedings, sometimes because of the heated dispute between the parties, sometimes the court actually asks that the parties themselves do appear, not just their legal rep. Okay, if the court wants them before the court. Now, family proceedings is a little bit more special. You can call it special or peculiar because of more personal vibes or emotions involved. Sometimes it's only one of those rare categories that the court will sometimes, or the judge will sometimes ask, you, Mr. So, can direct the parties, even if they have legal representative, they may direct the parties. You are the wife, right? Mrs. So, can you stand up? Now, and direct questions directly at the person, at the litigant. That's actually very rare. In most instances, the court will only hear the legal representative. Okay, the family courts are a little bit special, I would only say. Okay. What else? Direct that part of any proceedings be dealt with as separate proceedings. The court can also stay the whole or part of any proceedings or judgment generally or until a specified date or event. Stay means pause. Okay, just pausing for the moment, putting it on hold. Okay, that's what stay means in terms of civil procedure. Okay, stay. Okay, it's a very, very long list. So apart from just reading it out loud, that's why I'm trying to give you some examples. When we have consolidation of proceedings, it means that 2, 3 or more civil cases are, well, combined to be heard together. Okay? If you actually go into consolidation issues, you can actually have a total merger in which we call that the case is consolidated, or the cases are consolidated, or if they are partially overlapping, sometimes the court will direct, instead of consolidation, which is a total merger of the case, they may direct that case 1 be heard directly, or case 2 be heard directly after case 1. They may decide for the case to be heard one after another, maybe 1 and 2 or 1, 2, 3, 4, it doesn't matter. Okay? And that the evidence, most likely in those circumstances, the evidence reviewed or disclosed or submitted or adduced be used interchangeably in amongst those actions. Okay, makes sense, because the part of the purpose of consolidation or try together, the other one that I just told you, one after another, try together, the purpose is to save court time, because perhaps the background facts are very similar. They involve the same or mostly the same witnesses. Okay, so instead of trying the second case 3 months later, you might as well do it together. Okay, so try 2 or more claims on the same occasion. Direct a separate trial of any issue. Now you're not actually learning that in this course, but there is a mechanism called preliminary issue. Trial of a preliminary issue, and it's not in your course manual. It's called. It's under Order 14, capital A. Okay, 14A. And what it does is that it allows the court, or it is applying for the court to determine a particular issue before the main trial. So it's like a mini trial specifically on a particular issue. Because the rationale behind that application must be, is a qualifying criteria, is that it would either dispose of the whole case without the main trial, or substantially a very large chunk of it. Now, to give you an example of a case currently involved in, is we have party A, who is a lending company. Someone asked me about, like a mortgagee, okay, a lending company, so finance company, fighting against party B, okay, over one property. The mortgagee or the finance company is saying, yes, I have a mortgage over that property. Okay, that is my security for the loan I lend to somebody. The other party say, no, either by resulting trust or other constructive trust or adverse possession, I now have the beneficial interest in that property. So essentially 2 parties fighting over the interest over property. Now, one of the legal issues is who has priority. So in law, we have priority depends on registration with the land registry. Okay, that is one of the rules for property priorities. So that example I'm giving you is, if we decide who has priority over the registration, we can actually dispose of the whole case without going into whether the property was there was actually any resulting trust or any adverse possession, because those involve factual issues. But just by disposing of that legal issue on registration and priority on registration and interest, that disposes of the case. If the legal point can be won, the case wiped away, right? Because that's just an example that I can give you, right? So if that issue can dispose of the whole case without the main trial, that's an example of what we're talking about here. Oops, you can't see my mouse. Oh. Okay, so this one. Decide the order in which issues are to be tried. I think we've talked about that. Exclude an issue from consideration if it's not relevant. Dismiss or give judgment on a claim after a decision on a preliminary issue. Oh, that's exactly what I've been talking about. Okay. Take any other step or make any other order for the purpose of case management. Okay, that's just a general catch-all. Order 1, capital B, Rule 1.3 of the Rules of High Court. The court can make orders subject to conditions. When we go to applications for summary judgment or default judgments, you will see that most likely it's about payment of a certain amount into court as security. Because perhaps the defendant has been naughty, it's been dragging on, it's applied for extension of time 4 times. Okay? So it's been slack. So the court may want to say, okay, the court can do 2 things. As an example, the court can give unless orders. Unless, okay? As in, unless you do this, you'll be so and so. Okay? So unless order means, an example would be, unless you file the defense, unless the defendant filed the defense within 14 days of this order, the defendant will be barred from filing any defense. So that's an unless order. Okay? Or else can make it subject to conditions to make the defendant pay security into court, 100,000, whatever amount. Okay, subject to conditions. Unless order is an example of this. The court may also specify the consequences of failure to comply with the order or condition. Okay, if the party do not make payment of 100,000 into court as security for the action, the defense or the pleading will be struck out. Okay, or the counterclaim will be dismissed, etc., etc. The court may make any orders on its own initiative. It doesn't have to be by application of any party, but must give the party affected an opportunity to make representations. And that's just out of fairness. Right? That you don't rule or make judgment against somebody without giving them the opportunity to be heard. Order 1B, Rule 3. The court may make procedural directions by way of an order nisi. Order nisi means a provisional order. Okay, a provisional order. This word nisi. Okay, nisi just means provisional. There are different circumstances where order nisi will be made, and we'll see some of them during this course. So normally, when you have an order nisi, when the court make an order nisi, it would probably give a time within which the order will be made absolute. Okay, absolute. So it would become final, in other words. Okay, in this case, we're saying 14 days. Okay, order nisi will become absolute, order absolute, within 14 days, unless somebody or either party apply to the court to vary that order nisi. Okay, and a conditional order that will be made absolute unless something is done within a specified time. Order 1, capital A, Rule 3 of Rules of High Court, imposes on the parties to the proceedings or their lawyers a duty to assist the court to further the underlying objectives. Okay. I think you will see how many times it's regurgitating, repeating. Yes, we like to be more efficient. Yes, we want just resolution. Yes, the court should be more active. So these are all quite repeated. And I guess you should, within the context of studying civil procedure, you just have to bear it in mind. We're not going to ask you to recite those, okay? Don't worry, okay? We're not going to say, what does Order 1, capital A, Rule 3 says, spell it out. What we're really asking you to do is to bear in mind, at the background of your study, why all this application, why allowing, why not allowing, why rejecting, etc. when you go through all those procedures. Okay. At this moment, I think, well, when I first read them, I think they're pretty dry. Okay. So I don't blame you for having blank faces as well. But okay, so let's look at reflection activity 1. Okay, in the last chapter we discussed what we thought were potential weaknesses in our civil litigation procedures. You are supposed to have made your list of weaknesses on the system. Based upon the knowledge that you now know about the CJR, Civil Justice Reform, write down a new list of how the items in your weaknesses can be cured or improved. If you consider that CJR may not work to cure or improve those weaknesses, make suggestions as to how you think the weaknesses can be cured or improved. Okay, that's quite a long paragraph. Okay, so I guess from what we've read, 18 slides, just now on topic 2, it really is trying to say, it's like making vision statements, right? About what we're trying to do, how we can do it, and how it be more effective. It is quite too early, right? This is our first lecture, of me asking you, do you think it's done it? Right? We haven't learned about those procedures yet. But I guess what I can ask you is, are there any suggestions that you think, well, not based on your study, because we haven't studied the procedures yet, right? So what do you think? You said it's too costly, it's too timely, it's too complex, hard to understand. What do you think can be done? For example, there is resource centers for litigants in person. You do know what litigants in person means, right? People, plaintiff or defendants who are involved in court cases, but they do not have legal representatives. They are called litigants in person, right? So for example, we have resource centers for those and websites for those so that they can look up at least the basics. So what else do you think, what other suggestions can you think about, of to alleviate the problems that you told me about? Any suggestions? You've told me it's not perfect, right? It's far from perfect. Can you think of, I've just mentioned the resource centers for litigants in person. What else do you think can be done? Or do you think the rules can be further, well, we haven't learned them yet, so I can't ask you how they can be further simplified, right? It's a bit early to ask, actually, I think, this exercise. But perhaps I can ask you right at the end. Any comments? Suggestions? It's really, as it sounds, reflection, right? Food for thought. Okay, not. Okay.
You have sessions are always too long, and I think what you talked about, so if you can clear it out before the case, it would definitely help.
Sorry, that.
The clearing out, sorry, let me just find it again. It's the preliminary issue.
Okay, so maybe more frequent use of preliminary issue trials. Yeah, so that perhaps unmeritorious cases can be thrown out. Yeah. Stricter timelines, like that. Yeah. Yes. Any other suggestions? Okay, so no comment. I told you tonight's class is very light. Anything you don't understand from what we've gone through tonight? Okay, so now we can start on the next topic. What is it? I think it's pre-action considerations. Or else, I can show you navigation around the judiciary website. Which do you prefer? Sorry, we all all with masks, so you have to speak louder. I really can't. What? Sorry, it's majority by votes. The website? Do you guys mind? Okay. So any spare time belongs to you guys, so I don't really mind. Okay, so website it is. Any objections? So you don't have any access to Westlaw and Lexis, right? So not to other external database. So I just spent some time on the judiciary website, and also, are you familiar with the legislation website? Yes, no, yes?
E-legislation. Isn't there e-legislation?
Yes. Are you guys all familiar with it? It's very, very useful. Does that mean a yes or no? Please give me some indications. You are familiar? Okay, great. So just the judiciary website then. Okay. Okay, starting from afresh. Let's. Okay, so that is www.judiciary.hk. That's the website because it's so small. It's very tiny. Okay, accept and continue first. And then judiciary website again. Okay, how many times do I have to go through? Okay, are we on? Yes, we're on. Again. Again. Okay, forget about the messages. Now, that's the judiciary organization. If you want to find the names of the judges, list of judges, list of judicial officers. Let's go to what's most important. Judgment. Is it big enough? Okay, judgments and legal reference. Judgments and ruling. Judgments. Okay, go further into judgments. Now, you can do a number of, you can search for cases in quite different ways. You can search if you're just wanting to browse around and look at what the latest Court of Final Appeal cases are. You can go under the court, as it's pretty obvious here, right? Right? You can look for civil, criminal, etc. I'm told that there's no magistrate. Okay, it doesn't show up here. I've been told that magistrate cases, some of them now gets reported. It used to be none because there are too many. Right? You can assume the number of cases gone through by magistrates. Okay, first of all, if you know a case number, if I know a particular case number, I can search for the case number, like just now. Okay? You type it in, that's a quick search, if you know the case number. And then just press go. When you get in, when you look at it, you can see the case number, the party's name, plaintiff always first. The date, this date is not date of hearing, this date is date of judgment. Okay, and you press it in, pressing, going. And voila, that's the judgment. And with it, you can either print, of course, or if you want to save the judgment, I normally go for Word. Okay, and then you just, it will be downloaded as Word. Okay, and then you just save like normal. What if you don't know the case number? You just add after a contract case. If you what's common theme now? Okay, let's say. Look at the options that you can search on. These are like the qualifying criteria, right? What about, can someone give me an example? Let's say we want contractual breach or negligence, traffic accident. Negligence claim, traffic accident, fracture, okay? So fractured, something, fractured arm or something. I normally use this phrase and it would, oops, sorry, too specific. Okay, 466, can you see? Of course, the more criteria you put in, the less result it will return. Okay. If you use here, be careful what you're using. If, let's say, you use this phrase, any of these words, this would be looser, right? Any of either the word traffic or either the word accident. So it would increase your results, number of results. Okay, so look at this. These are personal injury cases, either at the High Court, HCPI, or DCPI, District Court. This is at the Court of Appeal. Okay, more personal injury cases. Okay, too many. Okay, so you may want to narrow your search. I won't teach you about Westlaw because you don't have access anyway. So that's wasting your time. When you, be careful to click on this button. This is called the stemming button. See the example it tells you, right? It means if you click this button, if you put in the word tax, it will give you also the result for taxes. So it doesn't limit it by just small extensions. Do you understand? Look at this. Okay, so be sure you click on it, otherwise you may miss some important cases. Okay, so that's that. Now you know how to use it now, right? And I showed you where practice directions was. Oh, by the way, you can also, other than case number, look at all the options. Why is it so small? Okay, so you can also buy parties representation if you know that, yes, Senior Counsel Hector Poon, Mr. Hector Poon was the counsel, then you can put in the lawyer's name. Or if you know the parties to the judgment, if you know it's Peter Wong, is the plaintiff, is one of the parties, you can also put it in here. If that returns a search. What else can I show you? That's about it. It's pretty simple there. You know, practice directions are here. Okay, you said that you're familiar with e-legislation. Are you familiar with the glossary? Are you familiar with the glossary? Okay, that's one thing from the e-legislation I promise you is useful. Okay, first thing first, you know that you can put in the chapter number, or, by the way, you know it's not cap number, right? You know it's pronounced as chapter number. right? CAP, right? CAP dot is only the abbreviation. You should always pronounce it as chapter number. So let's say I'm after theft order. Well, I shouldn't use theft, it's civil procedure. So just 4A is your rules of high court. So you know that if it's just pure number, if it's chapter 4, it's high court ordinance. All the subsidiary legislation normally has an alphabet after it. Okay, you can recognize that it's a subsidiary legislation if you see an alphabet behind the numbers. Okay, if it's pure primary legislation, it only has number. Okay, like High Court Ordinance is chapter 4. The rules of High Court would be 4A, for example. Okay, so you know that already. You know that you can look at chronological order of chapter index here, right? You can go for chronological order or just by the chapter number, or chronological order in English or Chinese title. You can actually find Gazette material here. Okay? Now getting back to the main page, you can find constitutional, probably the basic law, I guess. I can use it from here. This is what I mean. Okay, you may find it quite useful. Click in. This is like some people have been asked, what is a good legal dictionary? Well, this will be my first starting point. This is a glossary which gives you Chinese English translations. And it's official. Okay? Now, I'm going to give you some caveat, meaning warning, on how to use this. But first of all, how you use it. Now, pay attention now, even if you didn't so far this class. Okay, do not use head word. Do not use this, I repeat. This means the category. So unless you know exactly what that category is, you're at a loss. Use either Chinese expression or English expression. So if you want to know what contract is, type it in. See what's here? Can you see? Anything phrases the term itself, contract the term, contract itself, and the most commonly used phrases associated are here. Sorry, it doesn't help you much here. Okay, but this is a good Chinese English glossary. Caveat: it doesn't mean there are no other legal terms except this one. Can you see chapter number and provision? Can you see? This means, why is this list here? It's because of the legislation, as in past official legislation, like ordinances and subsidiary legislation. This is telling you, in relation to contract, the term contract, contract affirmed appears in this ordinance under this provision. You get it now? So this is under Chapter 71, okay? And Section 13, bracket 2. So if you go here, you actually find this term, the provision that uses this term. Okay, similar to all that. So again, beware, there will be phrases that are in case law, but because they are not contained in legislation, you won't find it here. Okay, but this is free dictionary, right? And the same thing happens. The same thing happens if you, or vice versa, if you want to go for okay, so if I type in the word convene, which means defend or defense, right? So I just do the same thing, and the same thing will happen again. Okay, in both Chinese and English, side by side. Some other practical thing that I can tell you, let's say is High Court ordinance again. Now, you do not work in the industry yet. If you need the whole legislation and you want to download it, don't print from here. Okay? You do not have to print from this screen. I'm not sure. Okay, be careful when you are on the e-legislation website. There is a inner, what I call the inner scroll bar here. Can you see I can scroll here? And I can scroll here. Okay? You see the two scroll bar. If you want to download the whole ordinance, scroll the outer scroll bar to the bottom. You should have learned this in legal system already. Okay? So we used to have all Hong Kong legislation in loose leaf folders. Okay? And your collection will be a whole bookshelf. Now, if this says here, verified copy with legal status, you no longer have to go to the loose leaf folder. This is as good and as official as the paper copy. Okay, so if it's verified copy, you would just download here. As long as it's verified copy, just press and download, like you would normally. Okay, it will ask you whether you want just Chinese or just English or both. I normally just download both, okay, English and Chinese. And they would appear side by side. I don't want to download again because I have plenty, but anyhow, when you download it, it looks like, I probably chose the wrong one because it's very long. It would have English and Chinese side by side, basically. Gosh. So, although I've shown you this, if you're familiar, fine. If not, just navigate it by yourself. Yeah, it's very easy. Well, basically, this whole thing moved, I think, in around 2017, 2018. The judiciary start to build up this e-legislation website. It's relatively new. It's relatively new. It's only been a few years. So, although they've put PDF copies on the web, on this e-legislation website, not all the copies have been verified and checked, word for word. So it's a very humongous exercise. So slowly and slowly, most ordinances now are verified copy. If you do not, if it's not a verified copy, you're not meant to use it. Okay, we're supposed to go back to the loose leaf folders and photocopy if we want to present to court, because that would be the official copy. But now you can. So that's what the downloaded copy looks like. And you will see, apart from the table of contents, it would have Chinese, English side by side. Okay, the provisions. That's all. Okay. Old sources. What they used to look like was this. They were in this type of, they are about this big, and each about this thick. So very archaic, okay, very old style. So they used to be in this type of loose leaf folders. Now no more. Okay, so anything else you want to know? I think that's pretty much what I can show you. The rest it just takes time for you to explore. Okay. Any questions? It's really additional bit and it's not, it's just that we have so much spare
Can
time.
I know that what is the fastest way to search case law for a specific provision?
Case law for specific provision.
The most recent case law.
the most recent case, well, it depends whether, okay, so you're not after a particular court, you're after a particular area of law. Is that right?
Yes.
So, for example, you've done contract law under obligation, so, well, let's say you want to know about the recent case law in misrepresentation. Okay, you all know that term now. You study contract, right? Misrepresentation. So you would, let's try to look as if we're starting afresh. So this is the judiciary website. We went into judgments, and judgments, right? So you would go for advanced search because it allows you to put in the qualifying phrases, right? So I tend to like to use all of them as phrase because it's more accurate. When you use phrase, it means those words in that particular order. Okay, so let's say I say exemption clauses. It must be exemption clauses in exactly that order, right? Exemption clauses. If I use any of those words, then it's either exemption or either clauses. You know that rationale, okay? So let's say I say contract. Okay, it's a bit small. Contract, misrepresentation. It can spell. Okay, and I've clicked my stemming. I normally just click select all anyway. This is more relevant for criminal law, but I just clicked it anyway. Go. Now, what did I do? I'm just trying to make it bigger. Look how many I've got, right? What if I want something else?
Can it narrow down to a specific section? Like,
Okay, so if you want, let's say, section 10 about robbery in theft ordinance, something like that. Okay, or let's say I want to talk about limitation ordinance. And I want to, yes, you can, just like any other way. If it's a phrase, section 7.2, just like that, you can do that. So it has to have both coexisting, right? I wouldn't put this two in the same box because it would not be I want it in any order, right? Either of this, as long as it has limitation order. I want to look up on section 7, bracket 2, limitation ordinance. So I just press go. 191. Okay, so all of them would have. And it would be highlighted. Let's say I just press on, this is a Lands Tribunal case. See all those highlighted phrase? Right? If you're careful, you may also want to do S.72, bracket 2, because the short form of section. Okay? But I think they are supposed to at least have one. Go for the official, because the court or the judgment is at least going to at least cite it once as the full word section. Okay, so the official wording is better. And if you want to say, what did you say you want to know about the most recent, right? So you can sort it by relevance or by date. In which case, the most recent will be on top. Okay? And by now you should know from, sorry, I keep on referring to Hong Kong legal system, but what can I show you? Now you know that this is the neutral citation, right? Neutral citation, but that is the case number. This HCA is the case number. That's the case, the judgment case, the judgment date. And let's say I want to, gosh, none of this is reported here. If you are lucky enough to have Lexis or Westlaw, and you want to look it up in the law report, you can distinguish between those that are not reported and the ones that are reported because it would say so here. That's the reported citation. Okay, if it says reported in blah 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 blah, that's the law report. Hong Kong Law Report and Digest. If it doesn't have that reported wording, then it's not reported. unreported. Simple as that. Any other questions? Oh, good. Okay. A few students asked me on notes making. I think by now you've started to show of hands, who of you make your own notes or summarize your own notes? You should be encouraged, so don't be shy. Okay? Okay, yes, good on you. Okay? As I told, some students come up to me and ask me during the break. By the way, the official lecture is finished, so if you are in a rush, you're welcome to go. The following is not really, even just now, it's not really the official lecture anyway, right? So some of you come up and ask me whether or how to make notes or which way is best. It's your personal style, right? It sounds very cliche, right? Just as if I'm not answering your question. But some people like very detailed notes. Other people have short bullet points, yet others have mind maps. So I told you that I had, or I still have OCD. I'll show you what I mean. Okay, for those who want to have a look. This is how my notes are like. Okay, no need to take pictures, you make your own notes. But this is not really helping you. Okay, this was my contract notes. So, I'm a nerd, okay? I'm a nerd. I put high efforts in my notes because that is all I study on. I don't go back to my course manual. I don't. This is actually MMU CPE, by the way. So I don't go back to my textbooks. I don't go back to my lecture notes, PowerPoints, nothing else.